well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam & Company. My name is Cam Edwards. Glad you're with me on the program today. A wild weekend out in Los Angeles, riots unfolding, and don't be surprised if anti-gunners try to use that as an excuse to push through more gun control in California, including a ban on the sale of Glock handguns. Might even see that bill amended to include a ban on the possession of those handguns. Also been a busy morning in the courts as we've covered at Bearing Arms. New Jersey Attorney General Matt Platkin and 15 other Democrat AGs suing to try to block portions of the settlement that the DOJ reached with rare breed triggers. That settlement included a requirement that DOJ and ATF return force reset triggers whenever practicable to those who had purchased them. And Platkin and the other Democrat AGs trying to stop that from happening, which, again, their argument is that, well, these are going to go to gun owners in places where these things have been banned. There's no sign that that's actually the case. I don't think these AGs have standing, but we've got it covered for you at bearingarms.com. We're looking at some other lawsuits as well that we expect legal developments in, but I got to hold off until those developments happen before I can actually talk about them. But again, a lot of stuff for you to peruse at bearingarms.com. Today's guest, by the way, Brandon Combs, the founder and head of the Firearms Policy Coalition. He had a recent piece at Town Hall talking about the Constitutional Concealed Carry Reciprocity Act, H.R. 38, which he says is a well-intentioned bill, but it does not yet live up to the name. So, what changes would Brandon like to see? Well, that is the subject of today's conversation. Take a look and a listen. Brandon, thanks so much for coming on the show. It's good to see you, my friend.
Good to see you. Thanks for having me.
Absolutely. And it was great to see your byline at Town Hall last week as well, writing about not constitutional carry, something that could be and hopefully will be real constitutional carry. But as you say, we've got a ways to go before H.R. 38, the Constitutional Concealed Carry Reciprocity Act, actually lives up to its name, right?
Yeah, that's right. I mean, it's a great starting point for what we're trying to do, but it has a long way to go before it kind of turns into that really protective measure that everybody needs and deserves. Our fear is that gun owners, they pass this bill as it is. Gun owners can say, well, hey, I'm going to travel to California finally, armed, or New Jersey or New York. They're going to drive through an area. They're going to pull over for a traffic stop or something, and they're going to go to jail because the bill doesn't protect most of the things that gun owners need them to be protected from.
All right. So, yeah, I mean, when we think about constitutional carry, we think of, okay, well, you don't need a government issued license in order to exercise your right to keep and bear arms, right? If you can lawfully own a gun, you can lawfully carry a gun. That's not exactly how this bill works as written, correct?
Yeah, that's right. The way that the bill is today, you would have to have a carry license and you would have to be carrying your government issued ID, right? A driver's license, for example. But you'd have to carry them both at the same time at all times in order to be protected. So let's say you have a carry license, right? And you have a driver's license, but you forget your wallet at home. Doesn't protect you, right? You are now exposed to whatever law applies where you are. And I think that's a fundamental problem, right? I mean, you should not go to jail for making a very simple, innocent mistake like that.
Yeah. You say that H.R. 38 also only covers one handgun, one magazine, and the ammunition that's loaded into that magazine, which I think is going to be a surprise for a lot of folks because most of us who carry semi-autos, I would say most of us anyway, have more than one magazine on us, right? Many people have, an extra 2 or 3 spare mags. So I didn't realize that if you had 2 magazines, you could be violating the law, right? You could be arrested for that.
Yeah, that's right. I mean, the way that they've constructed the bill, it applies to the handgun, right? It uses a singular form. And it talks about the magazine, right, and the ammunition loaded into it, right? So the language that the bill uses, strictly construed, only applies to the one thing. And I think a lot of gun owners know the axiom, two is one is none. Many people carry backups. It could be a backup firearm, could be another magazine, could be extra ammunition. But look, the bottom line is even if you didn't, one loose round falls on the floorboard, right? And that's it. Now HR 38 does not apply to protect you. So you're driving through, a school zone in New Jersey. You might be facing jail time again because the bill only applies to very, very specific things. What we're trying to suggest that they do is some pretty common sense adjustments to say, look, people shouldn't go to jail for forgetting their purse at home, right, or in the car. People shouldn't go to jail for having an extra magazine or a loose round or something like that. You should be able to exercise your right to keep and bear arms across state lines without having to worry about things like that. That's it, right? All we're looking for them to do is fix the bill so that it actually protects gun owners carrying the way that most people do. Lawfully.
You write at Town Hall, you say, unless HR 38 is fixed, state and local governments could expand so-called gun-free zones and then completely ban carry on all public property and impose thousands of different rules and restrictions. Would you like to see a federal standard then for what gun-free zones could be established under federal, state, and local law?
So there's two different issues here. First one is that HR 38 allows state and local governments to expand gun-free zones, right? In fact, recently, Republican Attorney General, writing in support of the bill, said, hey, look, we love this thing because we can we can still ban carry anywhere we want, right? And it's kind of made our point for us in this sort of ironic way. And yeah, I mean, you should not be able to ban carry that shouldn't be the feature of the bill. It should be a bug to fix. And I think that's kind of where we're at on that is you cannot say, look, you have a right to carry across state lines, but all of a sudden you can't carry across city lines because the city has said all of our public property is now off limits, which is exactly what this bill allows. I don't think that is what people are expecting from the bill. I think it's very unfortunate that they're sort of pitching this bill as this big fix when in reality, it just allows California and Illinois to do everything they've been doing. So I think that's a problem. The second thing to your question about sort of standards, our view is, the Supreme Court has already held what they call sensitive places, right? Can be banned, right? It doesn't say they have to be, it says they can be. Well, based on the history that we've done, the research that we've done, and all of our teams, great work on this. So we've litigated these issues, right? These sort of locational restriction issues, say extensively around the country. Based on everything that we know, we think that the standard should be: look, if you have actual physical security, controlled ingress and egress, right? You can't go in or out, freely. You have to go through sort of these hardened perimeters, frankly, right? You're trying to go through, and then you have actual security on the inside. If you're going to be disarmed and put your life in somebody else's hands, they should be obligated to then take up the responsibility of protecting you. And so we're saying, look, if you have real security, right, and you have actual security on the inside, armed security on the inside, historically, that might be sort of what distinguishes a public place from a non-public place and thus sensitive, right? And that's kind of what we're saying is, look, you can't just say sensitive places are everything.
And I agree with you. I mean, this actually came up in FPC's case, Schoenthal versus Raoul, during oral arguments last week. And I was listening to that. And it was one of the arguments that your attorney made is that, okay, so concealed carry is banned on public transportation in the state of Illinois. It's a sensitive place, but there are no magnetometers when you get on a bus or there are police stationed throughout the CTA system, but there are police stationed throughout the city of Chicago, right? There's no special protection, no special security. And in fact, I've got a story coming up a little bit later on in today's show about a shooting that took place on a CTA bus. And there are shootings and assaults and robberies that happen on CTA property all the time. So the state can call it a sensitive place, but they're not really treating it like it's a sensitive place, right? And that's your argument, which I agree with. I don't know that that's something that Congress is going to want to get involved in. That's my concern is that, I think when you get into that, you're going to have a lot of lawmakers, maybe even Republicans in those blue states that are going to say, and we gotta have some leeway for these states to decide on their own, time, manner, and place of carrying. I don't necessarily agree with that. I think, again, if we're talking about a right that is protected against intrusion by not just the federal government, by the state government, then it makes sense to have one standard, not 50 different standards around the country. But I got to say, I'm a little concerned that might be too big a boulder for Congress to push up that hill at this point.
Well, to be honest with you, I think that that's quite right. I mean, I don't think Congress has the fortitude to take up some of the more pressing issues of our day period. Congress really isn't doing its job, right? We have all these delegations to the executive, which we could talk about for hours. But certainly, I think you're right. It's going to be tough, even if they don't, right? So let's just say, for example, they say, look, you know what, preemption is off the table, because that's what we're talking about, is we're talking about preemption. Now, keep in mind, this is not new, and this is not special treatment for guns. There's preemption, for example, for shipping carriers, right? Like, you don't want UPS to have to figure out what the laws are in California versus Nevada, right? If they cross state line in on the 80 in Reno, for example, or in Tahoe. So, like, there's all of these preemption laws that exist already. Congress is very familiar with preemption. It does it all the time. If we're saying, like, hey, we don't like preemption because, for a lot of folks, right, they say states' rights, right? States don't have rights; they have police powers.
Yes.
Uh,
Thank you for saying that. That phrase annoys me.
It's I'm right there with you. It's a pet peeve of mine, but that's what they say, right? And so no. Clearly, in our mode of federalism, right? States have certain powers, and there should be these petri dishes, this experimentation. But here's the big but: the 14th Amendment said, right, the rights, the rights, the human rights, the inalienable rights apply to the states and local governments. So I guess my argument would be, under the 14th Amendment, which was literally designed to apply these rights to the states, to people in the states, you have the authority, I think, very clearly to say, if you want to protect carry, which is a fundamental right, that they can do that. And they can say, look, you cannot cross this line, which, again, Congress does that in all sorts of ways. But let's just say that that's not on the table. Okay, fine. If we're going to be pragmatic about this, then fix the rest of it. Right. That doesn't. You don't like our proposal on that. That's okay. We can agree to disagree there. But there are many other things that should still be fixed.
Yeah. No, and I would absolutely agree with you. In fact, one of the things that you mentioned in your column is the Gun-Free School Zones Act, which on the surface, I mean, this is a protection for gun owners, right? So if you have a concealed carry license, you can carry within 1,000 feet of a school. You don't have to worry about getting arrested. But more than half of the country no longer requires a license to carry. And yet that is the federal definition, right? That's still in there, that you have to have a license issued by your home state, or at least a license that's recognized by the state where you are. So what does that mean? I mean, we've seen like cities like New Orleans. They tried to make the French Quarter not quite a gun-free zone, but at least a constitutional carry-free zone, because they wanted to turn a police substation into a VOTEC by holding a class or two once or twice a year there. And therefore, okay, look, now the Gun-Free School Zones Act applies. You got to have a permit to carry in order to carry in the French Quarter. Would that language be cleaned up under HR 38 as it is, or is that something else that Congress needs to go back and fix?
So the answer is sort of.
Okay.
And it's actually a little worse than that, because the way that the federal law applies, you have to have a carry license from the state you're carrying in order to be exempt from the federal law. It cannot.
So it's not even reciprocity.
Not even reciprocity saves you from this, and that's the law today. By the way, they're prosecuting people under this law. There are at least 2 cases right now in courts of appeals that are being litigated by the DOJ in the criminal context. So it's a very real thing. But yeah, I mean, look, they can do that separately. We would certainly support that and love to see this fix, no matter what vehicle it went through. But yeah, they should take HR 38 and say, A, we're getting rid of this ban. At the very least, they need to get rid of the requirement that the license be issued by the state in which you're carrying, right? They should at the
Mm.
very least say that reciprocity, applies, and that any license exempts you from this. And I think that would, again, if we're working our way from what the best case to maybe the most politically expedient case, that's an option. They need to fix it somehow, and we've got lots of ideas, and I'm sure others have lots of ideas as well. We have great lawyers that can put together packages, and we've already prepared language on all of these issues. So, if they want to fix these issues, we're happy to hand them red lines and say, here, do this. And, if they don't like that language, then we'll find something else. But they need to fix these problems, but they do need to pass the bill, right? What we don't want to do is get, sort of to the point where we don't get anything done here. We need to get something done here before the midterms.
Yeah, absolutely. Absolutely. Again, you talk about providing some language to the lawmakers if they need it. I know that FPC actually kind of gave, I guess, sort of a wish list, or at least maybe a blueprint for the Trump administration as well. Talking about the need for a Second Amendment czar to be appointed. We have not seen that from the Trump administration. We've seen some good moves from DOJ, including the use of the Civil Rights Division for the first time in protecting our Second Amendment rights. I'm curious, what do you think? And this could be a question that you get to answer for an hour, I'm sure. So just at the 50,000 foot level, how do you think the Trump administration is doing so far in not just protecting, but advancing our Second Amendment rights? And have you heard anything about the appointment of a Second Amendment czar or somebody to sort of coordinate those efforts throughout the executive branch?
It's a great question. The first thing I would say is the DOJ civil rights. We had actually proposed that during Trump 1, so we're happy to see that finally came to fruition. And they've got Harmeet in there, and she's wonderful. So I think clearly they are taking steps. From my perspective, we've had great conversations throughout the administration, right, at the White House and DOJ and ATF, and there's this very, very strong sense that everyone that we've talked with in leadership is aligned on the goal, right? I think that's very true. Certainly different than the first Trump administration. This time they are very serious about doing that. But here's the sort of but, and where we can make some improvement. We have not yet seen this sort of unifying application of President Trump's agenda and the executive order. There are still lawyers within DOJ. The federal government's massive. We know that, way, way, way too big. There are still people that are working on the old rules, either because, the new rules haven't made their way to them yet, or maybe perhaps they don't like the new rules, and until they're forced to comply, they won't. And so you've got, and it's not just ATF, right? Gun owners need to think about commerce and the whole of government needs to be sort of under the same focus towards Second Amendment rights. And so that's what we're proposing is, look, put one person in charge, call him a czar, call him whatever you want. But, at the end of the day, have one person that is dedicated to implementing a consistent, faithful version of President Trump's pro-Second Amendment agenda and make everybody follow those rules. I think that's what we're asking for here. It's just a little bit more focus. And they've just done it. They've done it with the First Amendment and with faith, with the Office of Faith. So, we know that there's a model for them to do this, is what we're asking for.
Yeah. Well, I'd love to see it. And I hope that we do actually see that in the not too distant future. I hope we get to have you back on the show in the not too distant future as well, Brandon. I love having you on the show, and it's great talking with you. We obviously are huge fans of what FPC is doing. And always excited whenever you guys file a new lawsuit, because you definitely take it. You take the fight to these blue states. You again, what is it? Maximum freedom, right? For all Americans. That's the goal.
That's it. And at the end of the day, we're just here to serve, the people, you and your audience. And we're just happy to be here doing our part and be part of the broader community. But thank you very much for having me on.
Absolutely, man. Let's do it again soon.
Will do. Thank you.
My thanks to Brandon for joining us on the program. Looking forward to talking to him again in the very near future. By the way, I can hear Mario the rooster lurking outside my window, so he may be joining us here in a moment or two. Before that happens. Let's get to today's armed citizen story, our good deed of the day, and our recidivist report. We'll start there with a case out of Chicago, the headline from CWB Chicago. Gunman announced gang affiliation before shooting two on a Chicago Transit Authority bus, according to prosecutors. That would be a gun-free Chicago Transit Authority bus, by the way. The state of Illinois both bans firearms on public transportation. The Chicago Transit Authority bans firearms on public transportation as well. That apparently didn't matter to 18-year-old William Soto, who is accused again of shooting a 40-year-old man and his girlfriend on this CTA bus. Prosecutors say that Soto was already on probation for another gun case when he engaged in this most recent shooting. It was back in April 27th. 40-year-old man boarded a bus with his girlfriend, sat down directly in front of Soto. The couple were talking with each other, but they never spoke to the teenager. During the ride, though, Soto stood up, started speaking with the man who remained seated. Soto told the other man, "I'm a man," referring to his affiliation with the Maniac Latin Disciples. Okay. As the couple prepared to leave the bus, Soto allegedly threatened the man, saying he would, quote, have something for them once they were outside. That's when the man's girlfriend noticed a gun in Soto's pants, pulled her boyfriend away from the rear doors to keep him from exiting the bus. Standing outside the bus, though, Soto allegedly drew the gun, fired through the glass of the rear doors, striking the 40-year-old man in the thigh. Prosecutors say that Soto then looked through the window, fired again, discharged a third round as the bus drove away. A 22-year-old man on the bus had been wearing headphones, was not involved in any conversation, suffered a gunshot wound to his ankle. Thankfully, the wounds not life-threatening. Both men treated and released from the local hospitals that night. Now Soto charged with 2 counts of attempted murder, aggravated discharge of a firearm towards an occupied vehicle, and unlawful use of a weapon. He has been detained as a public safety risk, but again, already on probation for another gun case. The question is, why was 18-year-old William Soto out on these streets to begin with in the first place? And yet another failure of Chicago's gun control laws, yet another piece of evidence of these gun-free zones or anything but, and that lawful gun owners should have the right to defend themselves on public transportation. On to today's armed citizen story from South Carolina, where police determined a homeowner was acting in self-defense when he shot a home invader in Conway, South Carolina. This was last month during a home invasion. I'm not sure what day in May this took place, but police said the homeowner was shot at first and then killed the armed suspect, later identified as a 7-year-old man named Michael Dean. Now, I got to tell you, it's pretty rare for 70-year-olds to be committing home invasions, so I don't know if this was maybe a dispute between neighbors, if there was a dispute between individuals who knew one another. Regardless, the Conway Police Department says after a thorough investigation, they determined that the homeowner acted in self-defense, saying that the homeowner is protected by South Carolina Stand Your Ground law. They also say that this was an isolated incident, and the case is now considered closed. So, I would think that this would be a pretty easy call to make, honestly. You are in your home where you have every right to be. You are shot at first, so you have every right. First of all, even if the 70-year-old who committed the home invasion had not fired first, the homeowner still would have, I think, had the right under South Carolina law to defend himself in his home against what anybody would consider to be a threat to your life and limb when somebody is breaking in your home in the middle of the night there. But again, officially no charges filed in that case. Finally today, our good deed of the day, in the right place at the right time, willing and able to do the right thing. A good Samaritan in the Kansas City, Missouri area who stepped up to help a carpenter after the carpenter's trailer and tools inside were stolen. Fox 4 in Kansas City covered what happened to Kyle Hudson, and I guess there was a viewer who saw what was going on, and the Good Samaritan decided, you know what, I'm going to do what I can to help this guy out. So he donated more than a dozen pieces of equipment, wanted to remain anonymous, by the way, did not want any attention, but again, after hearing Hudson's story, he said, I got to do something. So he reached out to Fox 4, asked for help getting in touch with Hudson. And then I guess told the TV station, yeah, you can come along when I make the donation. But again, I don't want you to use my name. I don't want my face to be on TV. So he gave Hudson saws, drills, an air compressor, all items that he owned. He said they're items I've had for several years. He said, I love it. But he said, sell it or do whatever to get you some Milwaukee stuff again. So if you don't want to keep my stuff, sell it, use it to buy some stuff of your own. Hudson, by the way, says this means getting back to work sooner rather than later. He said with everything here, he can pretty much immediately get back to work. And he said that was pretty far out of sight. The Good Samaritan, by the way, telling Fox 4 that he feels for Hudson. Something similar happened to him about a decade ago. A thief stealing about $25,000 to $30,000 worth of work equipment out of his trailer. And he said that is why he was compelled to help. Kyle Hudson says he can't express his gratitude enough, saying, quote, there are good people out there. It might not be your next door neighbor, but there are people that are going to help if you speak up. Absolutely. In the right place, at the right time, willing and able to do the right thing to help a stranger in need. That's what this segment is all about. I'm glad to see that playing out with that anonymous Good Samaritan there in the Kansas City, Missouri area. All right, that is going to do it for this edition of Bearing Arms Cam & Company. Again, I would encourage you, check out bearingarms.com throughout the day. There's a lot of developing news happening, especially on the legal fronts. So we've got all of that covered for you, including the latest on that Attorney General's lawsuit against the DOJ settlement with rare breed triggers. But there is much more to come. We'll be back tomorrow. In fact, we're just getting started with this week's worth of programming. So we'll see you again on 2A Tuesday. We'll be talking with the CEO of Grab a Gun about the decision to take the company public and what he is hoping to achieve by becoming what some folks have called the Amazon of online gun sales. So we'll talk about that tomorrow. And, of course, keep you up to date on all the rest of the Second Amendment news and information from across the nation as well. Until we talk again, be well, be safe, and be free.